Support for today's episode comes from Amazon, sharing stories and initiatives focused on protecting water resources and strengthening water resilience in communities around the world. EPA keeps PFOA and PFOS drinking water limits, moves to rescind four other PFAS standards. Two proposed rules published May 18 restructure the Biden-era per- and polyfluoroalkyl substances PFAS drinking water regulation without abandoning it entirely. PFOA and PFOS limits stay in place. Four other PFAS standards are on track for rescission. The compliance deadline moves to 2031 under an opt-in framework, and a wave of state-level grant announcements hit the same week. For EHS compliance and facilities teams, the regulatory picture has shifted enough to warrant a fresh read of where obligations now stand. The U.S. Environmental Protection Agency, EPA, released two proposed rules on May 18, 2026, alongside nearly $1 billion in new state grant funding for PFAS treatment in small and disadvantaged communities. The announcement, made jointly with Health and Human Services HHS Secretary Robert F. Kennedy Jr., at a PFAS destruction technology event, frames the agency's approach as a life cycle-based strategy built around legal durability, implementation feasibility, and industrial source control, rather than a straight rollback of the Biden administration's 2024 final rule. The first proposed rule retains the maximum contaminant levels, MCLs, for perfluorooctanoic acid, PFOA, and perfluorooctane sulfonic acid, PFOS, at 4 parts per trillion each, the same limits established in April 2024. It would add an opt-in compliance extension, allowing utilities that can demonstrate legitimate implementation challenges to apply for up to 2 additional years, pushing their deadline from 2029 to 2031. Systems not seeking the extension remain subject to the original 2029 timeline. The second proposed rule moves to rescind the drinking water standards for 4 other PFAS, arguing the Biden administration failed to follow the Safe Drinking Water Act's SDWA required sequential rulemaking process when it set limits for fluorohexane sulfonic acid, PFHS, perfluorononoic acid, PFNA, hexafluoropropylene oxide dimer acid, HFPODA, commonly known as GenX, and a hazard index mixture of those 3 plus perfluorobutane sulfonic acid, PFBS. What the rescission of 4 PFAS standards means for compliance planning. The EPA's stated rationale for rescinding the 4 standards is procedural. The Biden EPA combined sequential rulemaking steps that the SDWA requires to happen separately, denying the public the opportunity to comment on whether regulation was appropriate before a draft rule was published. The agency notes that the outcome of a new, procedurally correct rulemaking could ultimately produce standards that are more stringent, less stringent, or equivalent. Environmental law groups, including the Southern Environmental Law Center, SELC, are calling the proposed rescissions a rollback of public health protections. The EPA's own language says the agency cannot predetermine the outcome. For compliance teams, the immediate practical question is whether existing infrastructure investment or planning decisions made around the 2024 6 compound rule need to be revised. Utilities and industrial operators that had begun planning for all 6 standards are now operating in a period where 4 of them are under proposed rescission and subject to a 60-day public comment period ending before the July 7, 2026 public hearing. The PFOA and PFOS obligations remain enforceable under the proposed framework. The 4 under rescission are not currently enforceable, but are not yet formally withdrawn. Legal firm Morgan Lewis noted that a federal district court denied EPA's earlier proposal to vacate the drinking water limits on January 21, 2026, preserving the status quo pending further litigation, which adds a layer of legal uncertainty to the rescission timeline. The grant wave. Nearly $1 billion distributed across states this week. Alongside the proposed rules, the EPA released state-by-state grant announcements on May 19th under the Emerging Contaminants in Small or Disadvantaged Communities, ECSDC, grant program. New York received $40.5 million, Kansas received $9.4 million, Illinois received more than $21 million, Wisconsin received more than $15 million, and the U.S. Virgin Islands received $9.4 million, among dozens of additional state allocations. With these grants, the agency has now made $5 billion available through the ECSDC program over 5 years. That total sits alongside $4 billion directed through drinking water state revolving funds dedicated to PFAS and emerging contaminants, and more than $6.5 billion in low-interest financing available through EPA's Water Infrastructure Finance and Innovation Act, WIFI-A, loan program. The combined federal funding pipeline for PFAS in drinking water exceeds $15 billion across these three programs. The EPA also updated its PFAS destruction and disposal guidance in April 2026, moving from a 3-year to an annual update cycle. Technologies highlighted in the updated guidance include granular activated carbon, ion exchange resins, reverse osmosis, electrochemical oxidation, supercritical water oxidation, non-thermal plasma treatment, and pyrolysis and gasification of PFAS-laden residuals. The guidance now recommends prioritizing technologies with the lowest environmental release potential when costs and logistical factors are comparable. Industrial discharge rulemaking and the TSCA reporting window. The broader PFAS regulatory picture extends beyond drinking water. The EPA's May 18 release confirms the agency is developing technology-based effluent limitations and pretreatment standards for industrial categories that discharge PFAS, with a proposed rule for public comment expected in the coming months. A draft multi-sector general permit, MSGP, published in late 2024 would require operators in 23 industrial sectors to monitor for 40 PFAS compounds quarterly under National Pollutant Discharge Elimination System (NPDES) authority, though that permit has not been finalized. Separately, the Toxic Substances Control Act, TSCA, PFAS reporting window opened April 13, 2026, and runs through October 13, 2026, requiring manufacturers and importers to submit data on PFAS manufactured or imported from 2011 through 2022. EPA has proposed 6 exemptions to that reporting rule, the most significant of which would eliminate reporting requirements for imported finished goods. Sustainability Soundbites water coverage is sponsored by Amazon. Visit the link in our show notes to learn more about Amazon's Spotlight on Water. For sponsorship opportunities with Environment and Energy Leader, please reach out to a member of our team.